Welcome once again to Lehto's Law. Here's Steve Lehto.
The U.S. Supreme Court just issued a ruling that was 9-0, meaning it was unanimous. All of them said, we rule this way. And this is always a fascinating concept. Now, I know I mentioned before about how often they do unanimous rulings, and they actually do it from time to time. It's not rare. It seems that the ones that make the news are often 5-4 or 6-3. But a 9-0 makes you look at it and go, wow, that's a resounding win for somebody. But of course, I believe they were reversing lower courts. So if you're a lower court and you get reversed 9-0 by the Supreme Court, it does make you wonder about how you're doing your job. Greg sent me the story. He pointed it out from conservativebrief.com, an article written by Martin Walsh. But I went and looked at the opinion to double check, make sure that we're getting the story straight here, and we are. The U.S. Supreme Court limits police power, to enter homes without a warrant. We're talking about the warrantless entry of a home. Now, we talked before about whether or not the police can run into a home chasing somebody without a warrant. And that's one thing. Now we're talking about them entering a home, and this is the interesting thing, for community caretaking. Community caretaking without a warrant. U.S. Constitution has been in the spotlight for years now, and debates surrounding the amendments continue to rage. So there's been a big win from the Supreme Court for those who like the right to privacy. And of course, the right to privacy is not in the Constitution per se, but we're talking about the right to be free from unreasonable searches and seizures. And a lot of people think of their privacy as part of that. The U.S. Supreme Court unanimously ruled recently that a so-called exception to the Fourth Amendment called community caretaking does not allow police officers to enter and search your home without first obtaining a search warrant, even if doing so could be in the public's interest. And you immediately see what the problem here is. If they say, well, we didn't have a warrant, but it's in the public interest that we enter your house and search it. Is it the public interest that you enter the house and search it without a warrant? Why can't you go get a warrant? So in this case called Coniglia versus Strom, the homeowner sued after police searched his house without a warrant in 2015. During that search, police seized 2 firearms, which the homeowner, recovered only after jumping through numerous bureaucratic hoops. It was a nightmare for him to get his stuff back. They entered his home without a warrant, searched it, found him, took him, and they eventually gave him back, but it was a pain in the rear end. So he later sued law enforcement, arguing that the search and seizure was a violation of his Fourth Amendment rights. And the police claimed that they acted lawfully under the community caretaking exception, which came from a case in 1973 called Dombrowski, where police officers, according to the Supreme Court, could conduct certain community caretaking functions if done in a reasonable manner. The problem, of course, is that they were talking about a case different than this. In that case, police had searched an impounded car without a warrant. So a car gets impounded, the police searched it, and they found something in it. And the Supreme Court said, you know something? The impounded car to be searched makes sense. We've talked about this. They talk about inventorying cars that are impounded, right? Well, and here, if a car gets impounded and there's something in it that could endanger society, you don't want it going to an impound yard where somebody could break into it and get whatever's inside the car. Or, for the inventory, we don't want the stuff stolen, but that's another story altogether. The ruling here overturned rulings by the Federal District Court and the First Circuit Court of Appeals. The Supreme Court ruled 9-0 that the community caretaking exception does not apply to your home, does not apply to a private residence. Clarence Thomas wrote the majority opinion, and here's the quote: "What is reasonable for vehicles is different from what is reasonable for homes." Katie acknowledged as much. That's the case, Dombrowski, Katie versus Dombrowski. And this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. So a car being impounded, yes. Your home? No. Thomas specifically rebuked the First Circuit Court for broadening the exception. The First Circuit's community caretaking rule, however, goes beyond anything this court has recognized. The decision below assumed that respondents lacked a warrant or consent, and it expressly disclaimed the possibility that they were reacting to a crime. The court also declined to consider whether any recognized exigent circumstances were present because respondents had forfeited that point. Nor did it find that respondents' actions were akin to what a private citizen might have had authority to do if petitioner's wife had approached a neighbor for assistance instead of the police. Neither the holding nor the logic of Katie versus Dombrowski justified that approach. It's true, Katie also involved a warrantless search, but the location of that search was an impounded vehicle, not a home. That is a constitutional difference that the opinion repeatedly stressed. In fact, Katie expressly contrasted its treatment of a vehicle already under police control with a search of a car parked adjacent to the dwelling place of the owner. So they even said, look, it's one thing to impound a car, but a car parked next to somebody's house is protected. So if the car parked next to the house is protected, you'd think the house might be protected also. But sometimes these logical conclusions don't jump out at some judges. This recognition that police officers perform many civic tasks in modern society was just that, a recognition that these tasks exist and not an open-ended license to perform them anywhere. So they can't come in, search your house, and go, we're doing this to protect the community from whatever you might have in here. No, go get a warrant. In rejecting extending the community caretaking exception, the Supreme Court rejected an argument from the government which had urged the court to uphold as legal the violation of this homeowner's constitutional rights. So this ruling is a big win for citizens and their Fourth Amendment rights, and will not allow law enforcement to conduct searches and seizures without warrants in your home. And now, there are people in my audience right now, and this is what I like about my audience, is that I can do a video a long time ago that relates to a video I'm doing today, and people will say, Steve, but wait a second. You said this in a previous video, and this video, and let's put these two things together and figure out how this works. And I just talked recently about how the state of Washington had ruled that a man's vehicle could be his home if he was living in it. So many people now are wondering, wait a second, if there's a ruling that says they can search the impounded car without a warrant, but they cannot search the home, can they search the car if it's your home? Well, that right there is the kind of distinction that would probably need to get ruled on by the Supreme Court, because here's the difference. They said that the car could be searched because it was being impounded, and during the impoundment, they needed to search it just in case there's something in there that might be dangerous to protect the community from whatever might be in the car, okay? That was their argument in the case of Katie versus Dombrowski. But again, that was a state court ruling out of Washington that said your home and your car can be one and the same. Now, here, the Supreme Court has said that searching the car to protect the community that's being impounded makes sense on some level. But to say we're going to extend that to your home, your domicile, your dwelling, is too much of a stretch for us. We're not going to let you do that without a warrant. So, would it extend to your car if you lived in it? It's hard to say, because if they're impounding it, then it seems that the rationale behind them searching it would make sense. But then again, if it's your home. And by the way, there's always another question that when the police do something without a warrant, the first question any judge is going to ask is, why didn't you get a warrant? And obviously, the argument in the old days where you're in hot pursuit of a suspect and they run into a home, you say, I didn't have time to get a warrant. I was running after somebody trying to catch them. And if I stopped to fill out some paperwork and find the judge to sign it, the guy'd get away. So you go, oh, okay, that might make sense, depending on the setting and so on. So if the police have a car that's hooked up to a tow truck and they want to dig through it for whatever reason, why can't they get a warrant? The car's not going anyplace. Car's hooked up to a tow truck. That thing's strung up like a fish on a stringer. So why can't they get a warrant? And so if the community caretaking function requires you to go into somebody's house to look for something that might harm the community, why can't you get a warrant for that? Because if you've got probable cause of something, fill out the paperwork and get a judge to sign it, then go in. And then you argue about the legality of the warrant, but not the legality of the search. So it's an interesting case. And like I said, 9-0. They all agreed on this one. So it's a great, great case, I believe. Greg sent it. Thanks a lot. ConservativeBrief.com published the article I just read from. Martin Walsh wrote it. Thank you very much. Very well written piece. The U.S. Supreme Court limits police power to enter homes with no warrant. There you go. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Did everyone see that? Because I will not be doing it again.